All right, I'm going to tackle the question, how do I work with a third-party engineer to bring my invention to life? Hi, I'm JD Houvener, patent attorney, owner, and founder here at Bold Patents Law Firm, also the author of Bold Ideas, The Inventor's Guide to Patents. I've worked with thousands of inventors, entrepreneurs over my 10 plus years doing this, and I've helped those inventors get over 500 patents issued. I'm excited to share with you some of my knowledge, background information on how you can work with someone, a third party, an engineer, prototyper, manufacturer, well before you get started on the patent process and what steps to take. So this question came up, and it was in this aspect of, hey, I'm just getting started. I've got this concept, right? And I want to be able to move that and protect it before I go to market. But I can't build it myself. This is technology I'm unfamiliar with. I'm inventing outside of my day-to-day work. I need someone else with experience in making these kinds of things to make sure it actually works. I need to prove it to myself that this invention does what I think it does. And so how do I work with someone who is not the inventor appropriately to protect myself so that they don't go run off and steal the idea, or I don't run the risk of them unknowingly getting access to information and sharing it with their internal staff, or worse, with a competitor of mine. So the first way is with a contract, right? Contract law will govern confidentiality and inventorship, ownership. Those are two big aspects that I want to make sure we touch on today. So you've heard about this acronym called NDA, non-disclosure agreement. Now that is true. On its own, it does the job of option number one, right? An option of criteria number one, where it makes sure that you and another party, or maybe more, are bound to maintaining confidentiality, meaning information you share between the two of you is going to stay between the two of you. And it could be between entities or individuals, one individual and one company, lots of different ways that it could go. It could be a one-way NDA or a mutual NDA. There's a little bit of complication here, and certainly there are templates and information you can get online through search engines where you could get something that looks decent. The problem is you want to make sure that contract is super enforceable, that if whoever is on the other side of the table breaches that contract, that you have a remedy in your local jurisdiction to go make sure that you are made whole right before a judge and jury if it comes to that. And so it will behoove you to talk with an attorney that has local law experience to make sure that if you're in Washington State or California or Idaho or on Florida, that a Florida licensed attorney is the one working on your NDA. Now, what's interesting is you can actually build out a larger contract or negotiate a working agreement that'll include a confidentiality clause within that contract. It doesn't need to be a standalone NDA that goes on top of the current contract. So take advice from local counsel. There's lots of different approaches that can make this relationship between you and an engineer, you and a manufacturer, or a prototyper, or even a university, so that you can actually go build this product, build your invention, your concept, because you're unable to, you need help. The second big prong on my list here is you want to make sure that inventorship is covered too. You as the inventor, as the one that's bringing the concept, bringing all the energy to the equation, it may very well be that as the product is getting built and developed, it becomes a new thing, that you have Invention 2.0 and iterates, okay? As you get closer to finalizing that go-to-market design, any inventions that get discovered, identified, any improvements of your invention, you will own if you do it right. That has to be in the contract that you are hiring this individual. Sometimes it's also called a work for hire contract. And so that type of an agreement will be crystal clear in that I'm hiring you to do this, and anything that you develop is going to be mine in the end, right? Any inventions, intellectual property that you develop in furtherance of this contract, I will own. So it's really important that you do that as part of working with a third-party professional. Then, of course, once you get those prototypes, get the manufacturing, and are able to validate that, yeah, this invention does what I was hoping it would do, that's the time to hire an attorney, perform a high-level and even a detailed-level patent search, and then finally file a patent application, whether it be a provisional or utility non-provisional. Awesome. Hope you guys had a good time today, learning something about NDAs, confidentiality, and working with third parties before filing a patent. Have a good rest of your day. Take care, everybody. Go big, go bold.